A neighborhood dispute over a damaged roof sounds pretty straightforward, right? But this story isn't so simple. It quickly spirals into a full-blown legal battle with conflicting photos, surprise witnesses, and a whole lot of he said, she said. So let's break down how this whole thing went down.
So, what happens when you are absolutely positive your roof is damaged and there's an insurance check just sitting there, but your Homeowners Association digs in its heels and says, nope, your roof is perfectly fine? This is the story of a case where the evidence was so evenly matched, it created a complete legal standstill. So, how in the world do you decide a winner? All right, let's meet our key players. On one side, we have Robert Vise, a homeowner in a condo community out in Sun City, Arizona. And on the other side, his HOA, represented by its board chair, Diana Goranok. And their whole conflict kicked off the way a lot of these things do, with some nasty weather. Now, this thing didn't just pop up overnight. Oh no. This dispute simmered for almost 2 full years. It all started with a big hailstorm back in October 2010. By early the next year, the insurance company was involved. Then there was a community vote. But a year after that, Mr. Vise felt like he had no choice but to take his HOA to court, which led to this final hearing in May of 2012. Okay, so what's really fascinating here is the amount of money at the center of this whole fight. After that storm, the HOA filed an insurance claim. State Farm sent an adjuster out who said, yeah, I don't see any hail damage, but there is some wind damage, missing shingles and stuff. The total claim was over $8,000. But check this out. After a massive $5,000 deductible, this little number is all the money the HOA actually got. So you can imagine the HOA board is in a real bind here. Not all of the 12 condos had the same amount of damage, so how could they possibly split less than $3,400 fairly? Well, they decided to put it to a vote, and by an 8-4 margin, the homeowners voted to just stick the entire payout into the community's contingency fund for future repairs down the road. But yeah, Robert Vise, he was not having it. He strongly disagreed with that decision. From where he was standing, that money was for one thing and one thing only, and a chunk of it had his name on it. So let's take a look at his side of the story. Look, his argument was pretty simple. The insurance check was for wind damage, and his roof had wind damage, period. He argued that the HOA was basically misusing the funds by throwing them into a general savings account instead of fixing his property like they were supposed to. And he didn't just show up with his opinion, he brought evidence to back it all up. So when they get to the hearing, Mr. Vise lays out what, on the surface looks like a really solid case. He got up and testified that his roof was damaged. He brought his own pictures as proof. He even had more photos from a professional roofing contractor, plus estimates for exactly how much the repair would cost. I mean, it looks pretty convincing, right? But then the HOA gets up and they tell a completely different story. They didn't just disagree with Mr. Vise about how to spend the money, they disagreed that his roof was even damaged in the first place. I mean, the HOA's position was just blunt. Mr. Vise's roof is fine, and the evidence he's showing you is misleading. They basically said he wasn't entitled to a dime of that insurance money because there was absolutely nothing to fix on his condo. And just like Mr. Vise, they came armed with their own evidence. And this is where the plot really thickens. The HOA brought in their own witnesses, including Mr. Vise's next-door neighbor, a woman named Donna Armstrong. Now, she claimed that the damage you see in those photos, well, that was actually on her side of the roof, not his. And then they dropped the real bombshell. An email from Mr. Vise himself, sent a full year earlier, where he states that he had already replaced shingles and cemented pieces that were sticking up, all on his own. So just imagine you're the judge, right? You're sitting there and you've got two totally opposite versions of what happened. One side brings photos and says, look, it's broken. The other side looks at those same photos and says, nope, that's the neighbor's roof. And besides, he told us he already fixed his. What do you do? This slide right here just lays out the problem perfectly. For every single claim that Mr. Vise made, the HOA had a direct and, frankly, a believable comeback. My roof is damaged. No, it's not. Here are the photos. Those are photos of your neighbor's roof. I need repair money. You told us in an email you already did repairs. It's a complete stalemate. Seriously, put yourself in the judge's shoes for a second. You've got two plausible stories. You can't exactly go back in time and look at the roof. You have no real reason to think either side is lying. So how do you make a decision? Who wins when the evidence is a perfect 50-50 split? So how did the judge break the tie?
Well, the wild part is the judge pretty much admits there's a tie in his official ruling.
So, the crucial point is right there in the judge's own words. He officially put it on the record that he couldn't give more weight to one side's evidence over the other. It was a perfect draw. The scales of justice were perfectly balanced. Okay, so that leads us right back to the million-dollar question, right? If nobody's evidence is better than anyone else's, does everybody just go home? Does the person who started the lawsuit get the benefit of the doubt? Well, the answer lies in a really important legal idea. And that big, game-changing principle, it's called the burden of proof. See, in any legal case, one side has the responsibility, the burden of actually proving their claim. And in a civil case like this, the standard for that proof is really specific. The standard is called preponderance of the evidence. That's a fancy way of saying that the person who brings the lawsuit has to show that their version of the story is more likely to be true than not. They don't have to prove it beyond a reasonable doubt like in a criminal case. They just have to tip the scales, even just a tiny bit, from 50-50 to, say, 51-49 in their favor. And that, right there, is why Mr. Vise's case completely fell apart, because he was the one who filed the petition. The burden was on him to prove his roof was damaged. Since the judge decided the evidence was a dead tie, Mr. Vise had failed to tip those scales. He couldn't prove his claim was more probable than not. And in the eyes of the law, a tie goes to the defendant. Case dismissed. So the consequences here were very real. Not only did Mr. Vise get $0 for his roof, but the judge also ruled that because he lost, he wasn't the prevailing party. That meant he had to forfeit the non-refundable $550 fee he had to pay just to file the case in the first place. This whole story leaves us with this really critical question, doesn't it? We might never know for sure if Mr. Vise's roof was actually damaged. He could have been 100% right. But the legal system isn't really about absolute truth. It's about what you can prove. And that's a powerful lesson in the huge difference between believing you're right and having the evidence to prove it.